Okay, so hi, Wendy. It's great
Hi,
to
how are
see
you,
you
Carol?
again. So I have a whole lot of things I want to go over with you. Um, the, um, the thing I wanted to address the scope of inequality women endure, like crimes like murder, rape, domestic violence, stalking, sextortion, sexual harassment, prostitution, human trafficking, as well as pornography, abortion, birth control, divorce, child custody, and financial inequities due to fewer job opportunities, lower wages, fewer promotions, lack of childcare, family leave, etc. Um, just like that's the kind of like big picture. But I wanted to ask you how not having the ERA adversely affects women's lives. Um, and the statistics, as we know, for crimes against women are staggering, and yet there's little acknowledgement in the media. How would that likely change if we had the ERA? And then I want to ask you to comment on the following cases, explain how things would hopefully have been different had we had the ERA. So,
Many people ask me, what's so important about the ERA? Women are doing fine. What rights do men have that women don't have? And the answer to why the ERA is so important is so profound that it really can't be explained in a simple, well, let me tell you about statute, 121 section B, because that's not the issue. And frankly, it's the wrong question. When people ask, what rights do men have that women don't have? I always say, that's the wrong question. It's not that men have rights that women don't have. The question is, what rights that exist must, as a constitutional matter, be applied and enforced equally on behalf of women?
yes.
The answer to that question is none,
Yeah.
zero.
Yeah.
Everything in women's lives is affected because the answer to that question is none. And I mean, from getting a dog license to freedom of speech to protection against all forms of crime, including homicide, domestic abuse, rape, prostitution, and even slavery. I mean, think about that. We have a 13th Amendment that appears to forbid slavery and doesn't say that it's okay to enslave women. It doesn't say that. It forbids slavery. But the 13th Amendment is modified by the 14th Amendment, because the 14th Amendment is where we get the guarantee that laws, including the 13th Amendment, will be enforced equally and applied equally, because the 14th Amendment has what's called an equal protection clause. That clause states that all persons shall be entitled to equal protection of the laws, including things like getting a dog license and the 13th Amendment, all laws.
Mm-hmm.
But because the United States Supreme Court has interpreted the 14th Amendment to permit unequal enforcement of laws when applied to women, the entirety of our legal system legally, and all of our laws legally, can be applied differently and worse on behalf of women.
And
That's how, go
how
ahead.
does that work exactly? Because sex is left out of the protected classes covered under the 14th Amendment?
Well, the Supreme Court did something very clever when it first had to answer the question, what does this equal protection clause mean? It was adopted by our country in 1868. And if you read it, you would say, well, this appears to cover women because it says persons shall have equal protection of the
Yeah.
laws.
Oh,
And
yes.
women certainly did think they were persons.
Yeah.
In fact, not only did women think they were persons under the 14th Amendment, they actually went to Congress in 1971 and argued that they had a right to vote, because although they didn't explicitly get the right to vote in the 14th or 15th Amendments, in fact, the word male was used to describe who has a right to vote in the 14th Amendment, and the 15th Amendment extended that male right to vote to Black men, but no women. But the women argued to Congress in 1871, we have a right to vote because we have a right to equal protection of the laws, including laws about voting.
Because we're persons, which we
Exactly, because we're persons.
which we actually didn't get recognized as such
No,
in
right.
1971, a whole
No,
100 years later.
well, here's what happened. Here's what happened. This is why people find it confusing. If you just go by the text of the Constitution, women don't have a problem. You have to read the Supreme Court decisions to understand the problem. And what happened in 1871 was, even though women went to Congress and said, we have a right to vote because we have equal protection of the laws because we're persons, of course, nobody endorsed that. So women filed suit. And a woman named Virginia Minor filed suit when she was denied the right to vote. And when she sued, she said, I'm entitled to equal protection of the laws, including the right to vote laws. And you can't deny me the right to vote because I'm a person. And the 14th Amendment says persons have equal protection rights. Well, that case got quickly up to the Supreme Court, which promptly ruled in 1874 that she did not have any rights under the Constitution to vote. And that, in fact, she had no right to vote because she was not a man, and only men got the right to vote in the 14th Amendment, and only Black men got the right to vote in the 15th Amendment. Mind you, what's really interesting about what the Supreme Court did was, in regard to her 14th Amendment equal protection claim, because she also made a privileges and immunities claim, a totally separate argument about why she was entitled to vote. She also argued it was an equal protection right of hers. And the Supreme Court thoroughly, completely, and totally ignored her equal protection claim. Completely. Now, why this is important is because if you were a woman filing under the 14th Amendment saying, I'm a person, I have equal protection rights, you would at least expect the court to say, if they're going to rule against you, no, you don't, because you're not a person, right? I mean, if they're going to rule against you, they should say, we know you made an equal protection claim and we know you're claiming to be a person, but we hereby rule as the United States Supreme Court that women are not persons. They didn't do that because that would have been too incendiary. That would have whipped women into a cause like nothing you've ever seen. That would have just ignited the nation to see in writing a declaration that half the population were not even persons. Wow. I mean, that would have made the Civil War look like playtime, really. So they didn't say that. And they knew they were doing it in this very clever, covert, not explicit way, and kind of leaving women in a perplexed state of, why did they ignore my equal protection clause? Now, mind you, as an
They just didn't comment on that.
They didn't comment on it on purpose. This was intentionally meant to keep women quiet, because after the decision came down in 1874, women weren't sure what to make of it, because they were saying to each other, why did they ignore Virginia Minor's equal protection claim? And the answer to the question is, we don't know. Does it mean women aren't persons? Well, we're not sure. Let's keep filing cases. Let's keep doing this, and let's see what happens. What women did, though, was they took great insult by what they did in that 1874 case, by ruling against Virginia Minor, but not at all saying whether she was even a person with equal protection rights. They did provoke at least intelligent women who were at that time fighting and really concerned about these foundational legal principles. You know, there were a lot of women fighting for suffrage at one point, but the women who were concerned about what the Supreme Court had just done, they tended to be more intellectual, because they were sophisticated enough to understand what the Supreme Court was doing, declaring women non-persons without saying so. So they immediately set out to fix the Constitution, and they did that in two ways. One, was to set a path toward winning the right to vote. They needed political power first so that they could then leverage their votes to be able to win other things. But they literally set out on two paths. One would be the right to vote, one would be equal protection of the laws, because those were the two things they had been denied in the 13th, 14th, and 15th Amendments. And I think we all know what happened with the suffrage amendment. It was first filed with Congress in the late 1800s, just a few years after Virginia Minor lost. And it took a very long time for that to finally be ratified in 1920. We know women finally got the vote in 1920, but not enough people understand why. And I think it's vitally important for us to talk about this today. The fact is, neither party supported women's suffrage, neither party. And Woodrow Wilson was in power when women were getting to the point where they were going to be powerful enough to use some of their voting rights against the Democrats, with Wilson, who was a Democrat, in power. Because remember, women did have some rights to vote in some states, especially in the western part of the country, which was growing and developing. So some of the leadership in those states, to attract women and to encourage families to move west, they promised women the right to vote. So the western states gave enough women the right to vote that when they started pressuring Woodrow Wilson about his opposition to women's suffrage, they were able to say, we can really hurt the Democrats. We, meaning all these voting women in the western part of the country. And then, of course, what really made the difference, and it was vitally important, was Alice Paul in the early 1900s founding the National Women's Party. I think it became formally a party in 1916. And what Alice did when she formed the National Women's Party is a lesson we need to remember today, which is that Alice said, neither party supports women's suffrage. That's why we've been fighting for it for decades and haven't made a dent. I'm going to make a fiercely nonpartisan women's party, and we will hold anybody accountable, regardless of party, based on who's in power, based on who can give us what we need. She didn't care if it was a Democrat or Republican. She was prepared to marshal votes against them and or in favor of them based on their position on the national women's suffrage movement. Mind you, there were a lot of women's groups that were kind of hostile to women's rights, and they were saying, let's just try to win votes in the states and not pester the national government. Whereas Alice was really adamant, and for good reason, felt strongly that that was an absurd thing to do, that some women in some places should vote, but not others.
Right.
I mean, she was dedicated to the idea of national suffrage because anything less would have been inhumane. And so there was a big divide at that time in the women's movement because an awful lot of, in my view, partisan corrupt groups, and by that I mean there were women who had been trained to support one party over the other to the detriment of women's needs. And we still have that going on today. You know, there are women who are party over issue, party over women, party over even basic human rights, which is really unfortunate. But Alice knew better. She was brilliant. People don't realize how brilliant she was. You know, she had a PhD from Penn and multiple other graduate degrees. She just kept getting degrees and literally was a genius. She was also a Quaker. And Quakers at that time were pretty well known for being egalitarian and having no sense that there were, you know, us versus them attitudes about anything, race, sex, anything. So once the National Women's Party was really solid in 1916, Alice did what we know she did. She started protesting. She formed, you know, the Silent Sentinels, ended up getting arrested. A lot of women did, including Lucy Burns. And they put so much pressure on Woodrow Wilson that he eventually came around. He had to, because also World War I was taking place. And these women at the White House were right outside with pickets and signs saying, how dare you tell the world stage that you're involved in World War I because you care about democracy. You don't even care about democracy in America, you fool.
Right.
And she's so embarrassed.
There's an interesting parallel today, isn't there, with Biden?
Yes, there is. Yes, there is. And that's one of the reasons I want to emphasize this issue of remembering where we've been and remembering why Alice Paul was so effective as a leader. I mean, most scholars agree we would never have won the right to vote, not when we did, if it hadn't been for Alice Paul and the National Women's Party. And not surprisingly, Alice Paul was marginalized as a result. She was too powerful. She knew what she needed to do to get women the power they needed by being fiercely nonpartisan, and that's why she had to be marginalized, and she was. After we got the right to vote in 1920, thanks to Alice, she immediately turned her attention to the ERA because she knew that even the right to vote is not equally protected until we fix the 14th Amendment, until we get women equal protection of the laws. Because remember, the laws includes the 19th Amendment. Mm-hmm. So women's right to vote isn't even safe today because we still don't have full equal protection rights under the 14th Amendment. And that's what Alice set out to do once we got the vote. Immediately, she filed, well, there was a draft of an early version of an ERA that was never filed with Congress. The first one to be filed with Congress was in 1923. And that actually said something to the effect of men and women shall have equal rights throughout the United States. It was important to use that men and women language because what Alice was trying to express was that women were the ones denied equal rights, both in the seeming language of the 14th Amendment with the word persons, but also in the Supreme Court's refusal to recognize women as persons. So it was only women who were excluded. And let me harken back to one other point. The Virginia minor case was just one example of where the Supreme Court refused to recognize women as persons with equal protection rights by just ignoring her equal protection claim. There were other cases where the Supreme Court made a list of people and categories of classes of people who are entitled to equal protection rights. And they included race, color, national origin, ethnicity, and we found out in the late 1800s, corporations were persons with equal protection rights.
1886.
Women were not on the list, and we were the only category of people not on the list. Right. It's important to remember that. Now, mind you, other categories of being have emerged since then, whether you want to call it, gay rights or disability rights. These are new categories of people, and they're important. All people deserve equal rights under the Constitution, but they weren't intentionally excluded. Women were intentionally excluded. Right. That's why Alice wrote it as men and women shall have equal rights. That proposal didn't go anywhere. And it was rewritten in 1943 to be the language that we know today. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That on account of sex language was meant to mirror, in a sense, the language of the 19th Amendment and to bring it into uniformity, if you will. But I think there was a lot of regret that we used the word sex instead of women. Again, because sex hadn't been excluded, femaleness had been excluded. And by using the word sex, we were suggesting that men were excluded too, and they weren't. So, but we had to live with that. And it got filed in 1943 and went nowhere. I mean, it literally...
The first one, the 1923 one, the Lucretia Mott Amendment, did have the language men and women.
Right, that's what I'm saying. Right, the 1923 used men and women, but when it was rewritten in 1943,
20 years later,
the language was changed to say on account of sex. The word woman was removed, which was very unfortunate because we were trying to repair a constitution that had added the word male. So we wanted to fix that by adding what was left out by use of the word male as an exclusionary category by including the word female or women. And then that was rejected in favor of the 1943 language, which used the word sex.
And who rejected that?
Well, let's just say there was a lot of pressure on the National Women's Party to refile in 1943 using language that mirrored the 19th Amendment, which did use the word sex, so as to keep the Constitution consistent. So there was a legitimate argument that consistency matters, but they also shouldn't have used sex in the 19th Amendment. So
Yeah.
it's important to remember why we are in this very awkward place today, both because of what the word sex means, but also what it has done to cloud the real problem. When you use the word sex, it's a lot harder for people to understand that this is about women. I mean, and historically, you have to work a lot harder to educate people to appreciate where sex came from, and why it's meant to refer to women. We don't really have any education curricula in this country at any grade level that requires students to learn the true history of women's struggle for equality. And that includes college, grad school, law school. Nobody learns this. So it's a challenge for women trying to do advocacy work because, and the statistics show this even today, most people think that women are equal, and they think the ERA was all set back in the early 70s. It's really a lack of knowledge caused by both propaganda that was very misleading in the 70s, and also a lack of any attempt to educate people at all. And we're still struggling with that today, even with a highly educated population that has access to enormous amounts of information with a push of the button on their phone. Things are getting better because we are able to provide information without the government deciding what we see and hear and learn. So things are better, but it's still challenging because women don't control the media. We don't, we have such little power over information and knowledge, whether it's coming from religion, higher ed, wherever we're getting our basic knowledge. If we were in charge, it would be mandatory that we're learning this, but we're not. And there's a strong reason why the moneyed interests don't want women to learn the truth about their history and where they are today, and why they're still subjugated and suffering across the board in all aspects of their lives, from mundane things like offensive language all the way up to femicide, and the fact that women are murdered at very high rates because they're female, because they lack a right to equal protection of laws against homicide. I mean, it's really that simple. You can put the dots together easily once you know, but if you don't know, then you don't put the dots together. And really part of our mission, I think, as activists today has to be that putting together of the dots so that people have a natural inclination to see their suffering as causally related to the Constitution. All women should see all of their struggles as primarily caused by their lack of equality under the Constitution. That's just a thing we need to be doing educationally, if not in schools, then amongst each other and in all fora where we speak as people. Even if you're invited to speak about your gardening skills, you ought to bring this up. I mean, I bring it up all the time, no matter what topic I'm talking about. And I say I'm sorry, but it's my obligation and responsibility and my pride that's at stake here. I cannot waste my breath talking to.
Sorry, my phone.
I always tell people I refuse to waste my breath talking about anything without seizing the opportunity to tell you about women's inequality. So, no matter what I get invited to talk about, I find a way to add this. So the next thing to remember, though, is once the 1943 ERA was filed, it like the earlier one, it went nowhere. I mean, there were little blips of efforts in the 50s and the 40s, but war is a nice distraction. And as we know, women did very much step up to fill in some important spots in terms of the labor force and other things when men were off at war. And there were things about the 40s and 50s, I think, that covered over the nature of women's suffering, because number one, we felt duty bound to help with the war. And then when the men came back, we were so happy the war was over. There was a lot of distraction. And then came the civil rights movement. And that's when Alice really stepped it up. And I think in some ways, brilliantly piggybacked on the anti-racism movement of the civil rights era. Of course, the civil rights era was also about women. I don't say civil rights and women's rights. I say civil rights, and I fully expect anyone listening to me to understand that women are part of civil rights. We don't have a
Right.
separate
Right.
fight. You know, women don't have rights that are different from civil rights. Civil rights are women's rights,
Right.
period. I mean, let's be honest about the importance of using that language expansively and not segregating out women's rights. I actually recently confronted Anita Hill on this because she was giving a talk somewhere, and under her name it says is something like expert in women's rights and civil rights. And I emailed her and said, what is wrong with you? Why would you do that? Why would you segregate women's rights from civil rights? And she acknowledged that it was wrong, and she blamed it on the conference, you know, hosts.
Mm-hmm.
But it's something we need to very bravely say to each other, and without fear of being criticized or worry that we're offending each other. We need to offend each other. And if someone uses inappropriate language, then we should correct them, even if they're on our side. There's no reason to be polite about it. Language is very powerful. So we come up to the civil rights movement. Women are just as anxious and just as angry, and they're demanding civil rights in education, civil rights in the workplace, civil rights in the Constitution, in the nature of the Equal Rights Amendment. So those were the big things we were fighting for. And one very simple thing we wanted was to open up Title VI of the Civil Rights Act of 1964, which prohibited discrimination based on race, color, and national origin in places of public accommodation. I'm sorry, federally funded entities, which of course would include places of public accommodation. And there was enormous backlash against women's request, and a lot of pressure mounted against women, suggesting that they were, who did they think they were, expecting
Mm-hmm.
to be added to a civil rights law? And why would they be so arrogant as to think that they were worthy of civil rights protections under Title VI with regard to federally funded programs? And women were kind of flummoxed by that. Like, why would anybody be opposed? But the reality is, because women weren't yet equal under the Constitution, Congress was very comfortable saying, we're not going to add you to Title VI. We'll give you a different law just for you.
Yeah,
And
it's that kind of this separate but unequal.
that's separate but unequal. Oh, this is Plessy versus Ferguson on steroids. They
Mhm.
explicitly gave us Title IX as a different and worse civil rights law that would never, ever be treated the same as Title VI, even though the language of Title VI is exactly the same as Title IX. The only difference is one says sex, one says race, color, and national origin. So you would think the courts would treat Title IX the same as Title VI. Absolutely not. Title IX got treated like crap. It is subject to much worse regulatory and enforcement standards. The rules are very different. Women can be mistreated and even discriminated against under Title IX in ways that would never be tolerated under Title VI. So if you're on campus, for example, and someone beats the hell out of you because you're Irish or Jewish or Black, that's a Title VI issue, gets instant redress on campus. Within days, the offender is gone. The standards in terms of how an offense is defined are very generous to the victim. It's just incredibly effective as a statute to stop race and national origin based offenses on college campuses. But if
Is
the
religion
effect,
included in that?
it's religion was added by executive order by Donald Trump, believe it or not,
Oh,
which, by the way, I think is illegal. I don't think the president has authority to issue an executive order that amends a statute in a substantive way like that, but he did. So people treat religion as if it's there. My own view is that it's not legally there. It needs its own statutory amendment to fix Title VI to add them. But what people don't appreciate is that because Title IX is subject to unequal enforcement under the 14th Amendment, it's legal for schools to treat women differently and worse, even if the exact same thing happens to them. So that same person who beats up a student because they're Black or whatever, if they do exactly the same thing to a woman and say, I'm beating you up because you're female, I hate females, I'm beating the hell out of you because you're female, the school is allowed to treat that incident differently and worse than if it happened to somebody else. And that's only legal because we don't have the ERA. If the ERA were in place, that would be illegal. So things like that, sometimes I fear aren't as obvious to people because we're so used to Title IX being treated worse that we don't understand, and we don't even ask why. Why is Title IX treated worse than Title VI?
Yeah, and a lot of people don't even know there is a Title VI.
They don't. Every time I give a talk on Title IX, I ask the audience, who's ever heard of Title VI? No one ever raises their. So I use this as a perfect example of why the ERA matters. But more important than even explaining why the ERA matters on this issue of Title IX enforcement is that we teach ourselves to ask those questions.
Right.
We should be saying, why is Title IX different than Title VI? That if we don't ask that question, we never get to the answer, which is because the ERA is not in the Constitution.
Right. This seems very related to the whole issue of level of judicial review. And
Yes. So let's back up now and talk a little bit more about what the Supreme Court has done over the years to make clear to women, number one, that they were not persons, and then when we finally became persons, that we might have had personhood, but it was going to be second class or third class personhood at best. And the way that happened, again, was both slow and, in a sense, covert, because there was nobody wanted on the Supreme Court or any other branch of government, nobody wanted women to see clearly that they were unequal. So a lot of this was done in ways that was designed to obfuscate that reality. So again, starting back in the late 1800s, the word persons is used in the 14th Amendment and says that persons shall have equal protection of the laws, but the Supreme Court refused to recognize women as persons and kept recognizing other groups of people as persons, but never included women. And as I mentioned before, even when women filed equal protection claims, they were just ignored. It wasn't that the court would rule against them. They would just pretend they didn't have them, so they would ignore them, which is outrageous. It's worse to have a court ignore your claim than to rule against you. At least if the court rules against you, you have something to read and to fight about and to advocate about.
Right.
Ignoring women completely because they weren't persons was the ultimate insult. Really outrageous and
that makes it impossible to fight it because it's
impossible to fight it because it's invisible and impossible for women to rise up.
That's so much of what women's experience is, invisibility.
Yeah, until you come up with, until you have
horrible things that happen to women that, it's like if the same stuff happened to any other group, the news would be all over it, but
well, that's because women are not fully equal persons.
I know.
So it's perfectly legal.
It's so outrageous because, it's treated like, the rates of homicide and rape and every other horrific crime that women endure because of our sex is just, treated like any other news day. It's like, it doesn't even,
it's treated
reach the level of
all harms to women. All harms to women are ignored or diminished because that's what the Constitution says. And that's why people do it. It's in our constitutional DNA. That's why in my new piece that I just published, a very long piece with 480 some odd footnotes, I refer to this as constitutional terrorism. It's a phrase I coined to describe the experience women go through when you live under a regime that has declared to you this very simple reality. All government officials, in all branches of government, state and federal, at all times, have the constitutional authority to treat you differently and worse simply because you are female. That's women's reality.
Yeah.
And if you ask a woman to live under that constitutional regime, you are asking her to live in a constant state of terrorism. That's what we know. The concept of terrorism is that you don't feel free to walk around and exist in the world because you rightly fear that harm will happen to you simply because of who you are.
Right.
That is terrorism.
Simply for existing. Yeah.
They're existing. Fear of being harmed because you exist is a form of terrorism. When the government allows it, it is government terrorism, or as I call it in America, constitutional terrorism. And we have to think about it that way in order to appreciate what we're saying, which is that every aspect of our lives is affected by a constitution that has made it okay for all government officials to treat us differently and worse under all laws, all policies, all regulations, at all times. And it really is that profound. And it's sort of scary. I mean, I think there are some women who don't want to think about it because it's too scary. It's better to just not know. And I do say this to people that I share my long paper with. If you want to read this, great, but you can't unknow it. Some people don't want to know. And I have to respect the fact that there are people who would rather not know because it is overwhelming to know too much about how bad things are for women. So, but anyway, to get to the point of the scrutinies, which is important, the Supreme Court basically leaves us as non-persons from 1868 when the 14th Amendment was adopted. So it's important to just appreciate where we've been and where we've come to on this question of personhood, the ERA, equal protection of the laws. Because as I mentioned earlier, in 1868, the 14th Amendment is adopted and it says persons have equal protection of the laws, but the Supreme Court makes clear in decision after decision after decision that that does not include women. Not only because it keeps publishing in its decisions the list of categories of people who are protected and women are never there, but when women file equal protection claims, the court just ignored them. So that's the way, that's the simple way of saying to women, don't even bother to file an equal protection claim in your case. We're not going to give it any respect whatsoever. We're just going to rip that page right out of your lawsuit because we don't have to recognize you as a person. That was how things were for a very long time until women started really rising up in the 60s and pushing for the ERA and pushing for civil rights. And there was so much pressure that the Supreme Court actually decided a case in 1971. Remember, the ERA didn't pass Congress until 72. The Supreme Court decided Reed versus Reed in 1971 and said, for the first time, women are persons under the 14th Amendment Equal Protection Clause. It was the very first time the court connected those dots for us. And you would think women would be delighted, except for the fact that the court added, well, you're going to be persons moving forward. You can be persons, which means we could file claims, but we're going to enforce your equal protection rights unequally. I mean, think about the mental gymnastics included in that statement. You're going to be able to have equal protection rights, but when you go to court to enforce them, they will be enforced unequally compared to other people. So women got equal protection rights. Talk about making things complicated and confusing. How do you now teach the women in America that they're unequal when the court said you have equal protection rights? You have to explain it in ways that take so much time. And it goes something like this, because this is what they meant when they said women will have equal protection rights, but they'll be equal protection rights. This is what the court said. When women have a claim because they have been treated unequally by the government, they can file suit, but their lawsuit will be reviewed in the courts under the lowest level of judicial review called rational basis scrutiny.
Yeah. So that's where that comes in.
That's where rational basis comes from. And for people who don't know what this means, I use this triangle to explain. Let's picture a triangle with two horizontal lines across. So you have a tiny triangle at the top and then one about 2/3 of the way down. Now you've got three slices of triangle horizontally.
Uh-huh.
A tiny little triangle piece at the top is where what we have, what we call strict scrutiny. That's the judicial review standard that is the most protective, because that tiny piece of the triangle reflects the percentage of discrimination that the courts will tolerate for people with that strict scrutiny level of review, such as race and national origin. They're way up there at the top with that tiny piece of triangle. That's strict scrutiny. Almost no discrimination makes it through at that top piece of the triangle. At the bottom, that big, huge, fat piece at the bottom, that's rational basis scrutiny. That's where the court stuck women. And you can see, relatively speaking, it's such a huge piece of the triangle that reflects how much discrimination is tolerated by the government, by the courts, for sex discrimination. In other words, you can discriminate this much, relatively speaking, and you can only discriminate this much for other categories of people. 1971, we got that bottom piece of the triangle, rational basis, which lets in virtually all discrimination against women. So it was a victory, but only a tiny little victory.
Mm-hmm.
And guess what happened as a result of the Reed versus Reed case? Well, the ERA was at the time on the front burner at Congress. Finally, Alice Paul had done all that she could. She had leveraged all the pressure she could. She was an amazing powerhouse, and she got Congress to finally agree to put the ERA through. Mind you, it would then have to be ratified by the states. But here we had enormous power with the support of all that was going on in the civil rights era. Congress couldn't politically get away with not passing the ERA, and Alice knew that. So the ERA is up before Congress, but guess what happens in 1971? Reed versus Reed comes down. Now, again, you'd think that was good for women because at least we were persons. But the reality is Reed versus Reed almost destroyed the ERA. It undermined the ERA terribly for two reasons. One, it took the political wind out of our sails, because our argument in support of the ERA before 1971 had been, we don't exist. We're not persons. We don't have any status under the Equal Protection Clause. Boom, the Supreme Court gives us status. Really bad status, but status. And that made the ERA a harder sell. And in exchange, that gave Congress the political space it needed to attach a 7-year deadline to the ERA. There was no fight against it because women couldn't argue anymore that they desperately needed the ERA because they weren't even persons yet. Now they were persons. So no one's complaint about the 7-year deadline made much of a ripple in DC. Alice was furious, and she knew, and she was crying the day the ERA passed Congress in 1972, only because it had a deadline. And by the way, both parties supported the deadline. Remember that. And remember back to when we talked about suffrage. Neither party supported women's suffrage. Neither party supported the ERA, but both knew they had a great deal when the 7-year deadline was attached to the ERA, because they both knew that would be easy to defeat. Defeating the ERA in 7 years would be fast and cheap for both parties. If the ERA had had no deadline at all, which is how it was drafted every year up until 1972, it was changed in 1972. And the only reason politicians got away with adding that deadline was because the Supreme Court decided Reed versus Reed, giving us this tiny little bit of personhood, but in exchange for total destruction of full equality. So we get the triangle now. Women are at the bottom. Everyone else is at the tippity top. There's one other category that I'll get to in a second, but women were really not happy with the 7-year deadline. And perhaps not surprisingly, a lot of women's groups who had been hostile to the ERA, like the National Organization for Women, like Feminist Majority, they were delighted with the 7-year deadline. That was going to kill the ERA, and now didn't even do anything to help with ratifications in the states after the ERA was finally passed in 72 until something like 1976, because by 1976, it was clear the ERA would never make it through 3/4 of the states, which is what we needed for it to be ratified. It had to pass Congress, and then it had to be ratified by 3/4 of the states. We didn't even, we got to 35 states, and there was nothing was going to get us those next 3 states. And it was then that the National Organization for Women started working on getting more states to ratify. And if you read their strategy, it was really horrendous. I mean, they had resources all over the place rather than targeted resources in the states where we knew we had a chance. If you read what they did politically, it just looks like they were trying to undermine the ERA while appearing to be working for it, which was typical of now at the time. Remember, when they were founded in 1966, and really, were piggybacking on Alice Paul's great work for decades, they opposed the ERA. Betty Friedan at the first annual convention announced that now would be opposing the ERA, and women were livid, absolutely livid. And Alice Paul convinced the membership to rise up against Friedan, which they did, and they very, very meekly supported the ERA eventually. But if you read the congressional record, they don't even get a mention. Now gets almost no mention at all in terms of why Congress felt persuaded to pass the ERA. They talk about Alice Paul, the National Woman's Party. They were the ones who got the ERA done.
And the deadline, if I could ask you for a second, the deadline was only in the preamble, though, right? It wasn't in the actual amendment itself, which is why.
Right. Well, so let me get to that later. So the ERA passes Congress, gets sent to the states for ratification, but it's got a 7-year deadline. And we didn't come anywhere near 38. We got 35 by the time the deadline expired. There was an extension of the deadline in 1979 that extended it to 82, which was about almost 3 years more. So it was basically a 10-year deadline. But we didn't get any more states even after the extension.
On that time
So
period.
a lot of women gave up in 1982.
I was one of them.
In 1982, when the 10-year deadline expired, a lot of women gave up, but not all. There were people who still felt rage about the deadline.
No, we were so devastated. We didn't know we had any options.
Right. And you know what? For good reason, people thought they had no options, but they were still angry about the deadline. They didn't know what to do. They didn't want to start over, but they didn't know if they should. And there was a lot of rumbling. And then something wonderful happened in 1992. So 10 years after the 10-year deadline expired, something wonderful happened, which is the 27th Amendment was ratified. Now, women,
202 years.
Women were livid because that amendment, which pertains to the timing of congressional pay raises, was ratified 203 years after it passed Congress in 1789. So women turned to each other immediately and said, if that amendment gets 203 years, we can't possibly only get 7. They weren't sure what was going to happen, right? Or 10. But what women were saying was, we're not sure where this is all going to fall, because this was unprecedented legal territory. But we have a confidence that a court will not tolerate such a frivolous constitution that it allows one amendment 200 years to ratify and another only 10. So they started to fight back, and they said, we're just going to go get 3 more states to ratify. And once they do, we'll go to court and argue about why the deadline is not valid. They weren't even thinking about its placement in a preamble at the time. They were talking mostly about the silliness of having such a frivolous constitutional amendatory process. Well, things got even better in 2012. It's funny how this was happening in like 10-year chunks. 82, the deadline expires. 92, the 27th Amendment happens. 02, there wasn't much that I know about, but 2012, so, another 10 years later, the archivist of the United States issued a public letter saying, if women get 3 more states to ratify, I will publish the Equal Rights Amendment in the Constitution as our 28th Amendment. Women were so excited because the archivist, the country's librarian, if you will, is responsible for putting all new laws in the books. And in particular, with regard to amendments, he's mandated, not like allowed, mandated to publish new amendments in the Constitution forthwith the minute the last necessary state ratifies. So he was asked about the ERA specifically, because of the deadline, what will you do if we get 3 more states to ratify? And he wrote back, I will put the ERA in the Constitution. And the rescissions, there were some states that either rescinded or tried to rescind. There were 5, 3 actually voted to rescind, 2 attempted to. But the 5 states that rescinded, he even wrote in that letter, and rescissions don't count, which basically all scholars agree is true. The rescissions don't count.
Right.
So women were so excited in 2012, we went hog wild about the ERA. We went to Nevada and got them to ratify in 2017. We put a lot of time and energy into then getting Illinois to ratify in 2018. And then we got Virginia as the last necessary state in January 2020. Now, mind you, no one thought that just because we got all of these states that everybody was going to roll over and let the ERA be in the Constitution. We knew there would be a problem in the sense that the anti-ERA states would probably try to go to court and fight it. And they did. And I, as an impact litigator, had been planning litigation for years. As we came forward toward 2020, I was aware of what the strategies were and planning to file things in court. So I was developing a brief, not sure who was going to sue or where it was all going to happen, because we weren't clear who the opponents would be, where they would file, what we would do. We didn't know for sure that what the archivist was going to do. So it was kind of a wait and see. But meanwhile, in the years leading up to 2020, I was giving talks all over the country. I gave a talk at the Belmont Paul House, the National Women's Party House in DC. I gave a talk at William and Mary. I gave talks around the country about what we were going to do once the last state ratified. And at one of those talks, and I was very clear that we deserve to win, because even though not everybody agrees, there's at least some scholarly support for our view. So as long as there's some scholarly support for our view, we should win, because it then becomes a policy or political question, and we're going to have somebody on our side. The Democrats likely would be on our side. That was my feeling at the time, naive as that might sound. And at one
I claimed they were.
Well, yeah, but exactly. Exactly. And not that I wasn't cynical back then, but I just thought this would have been too difficult for the Democrats to resist, but I was wrong about that. Yeah. So what's interesting is when I gave my talk at the Women's Club, at the Women's Party headquarters in DC, there was an audience of about 100 women, and they invited not only me, but also Ellie Smeal from the Feminist Majority to give a talk about the plans for the ERA after Virginia ratifies. And I gave my talk and said, look, this is what we're going to argue. The ERA is valid because 38 states have ratified it, and that's all that Article 5 of the Constitution requires. Therefore, we win. As for the deadline, deadlines are not valid because, among other things, Article 5 doesn't say anything about deadlines, and Article 5 explains exactly how the Constitution gets amended. It says Congress shall propose and the states shall ratify. That's it. There's nothing in there about deadlines. And because of that, the deadline is invalid. Now, my alternative argument was, even if Congress does have the authority to put in deadlines, which I still think they don't, but even if they do, they have to put them in the text of the amendment itself, because states can only ratify amendments. They can't ratify preambles or adjunctive laws that get tacked onto an amendment. And this was, in a sense, a preambulatory, if you will, aspirational, gobbledygook that they stuck into the introductory part of the ERA. In other words, I'm sure you've seen this where a law says, whereas such and such, and whereas the other thing, and whereas this and that, blah, 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 blah. Therefore, we propose the following statutory law. And
Right,
the language of the statute is just the thing after you're done with all the whereases.
right, right.
So this preambulatory clause that said that there should be a 7-year deadline, later extended to 10, was, in my view, unenforceable because it wasn't part of the text of the amendment itself. And you cannot impose on the states a restriction on their right to ratify or not. You cannot impose a timeline on them because that undermines their equal balance of power in the amendatory process, which is what the framers were very clear about, that had to be done. There has to be balance equally between the national government and the states when the Constitution is amended. That's what a healthy.
The 10th Amendment.
Well, that's not quite related, but in a democratic republic where you want balance of power between the national government and the states, the most important thing you can do is make sure that their powers are balanced when they amend the Constitution. Otherwise, you don't have anything remotely close to a democratic republic.
Right, it's
you have
centralized
a totally centralized national government that can do what it wants. And this is what I actually wrote in my briefs that I then was filing. If the national
kind of
government,
related, but not really. I mean, it's
no, the 10th Amendment is, as a states' rights thing, is a way. Well, let me not go there yet.
okay.
The brief that I filed emphasized that if the national government, meaning Congress, can tack on a deadline to a new proposed amendment that the states then have to think about ratifying, if it can restrict the amount of time the states have to decide the amendment, then the entire amendatory process is in the hands of the national government, because they can put a long deadline on things that they like, a short deadline on things they don't like.
Right.
I mean, they can completely manipulate the Constitution to serve the national interest, which is contrary to the interests of the people. The people speak through the states. We know that 90% of the American people support women's equality. Their will is not being done because the states through which the people speak in a truly democratic sense, the states that represent in a representative way the voices of the people, are being disrespected by the arbitrary imposition of a deadline that made this declaration to the states. Get it done in 7 years, or else, or 10, or else your role in the amendatory process is meaningless. Now, the states don't want to be told how much time they have to ratify, and historically, all the way through the early 1900s, no amendments. So we're going up to around the 18th Amendment. No amendments had deadlines. It was a relatively new invention, and of course it came with, as Congress was getting more powerful and more arrogant and more corporatized. So from the perspective of let's keep our country healthy, people should be wildly opposed to this idea that Congress has the authority to tell the states how long they get to ratify, especially not when you look back at what Article 5 says. I mean, Congress could have, the framers of Article 5 could have said, we want Congress to be able to set a reasonable timeline around how long it takes for the states to ratify, and we don't want amendments to be open for all time. They didn't do that, and there's nothing in the notes to Article 5, nothing that indicates that anybody wanted there to be power vested in Congress to restrict how long the states had to ratify. So, there are a couple of cases on point that people have read and talk about a lot. One is a 1921 case called Dillon. Another is a 1939 case called Coleman. In Dillon, the court had to answer the question, our deadlines, well, there was a deadline because this was the Prohibition Amendment, and the Supreme Court was asked to answer the question, when does an amendment become valid? Is it the minute the last state ratifies, or is it when the archivist puts the amendment in the Constitution, literally, types it in?
Mhm.
And the court said the minute the last state ratifies is when an amendment becomes valid. We don't care when the archivist publishes. That's a
Okay, so
ministerial.
the ERA is valid as of January 27th, 2020.
Exactly. And no case has ever decided the question that our case raises, which is, what if the archivist doesn't publish? What if it's based on a deadline that's unconstitutional? We have, we did fight about this, and as soon as Virginia ratified, in fact, before Virginia ratified, because I had some concerns, I didn't even wait for Virginia to ratify. In early of January 2020, I filed a lawsuit in Massachusetts federal court against the archivist, asking the court to order the archivist to publish. The archivist the next day issued a statement, the day after my case was filed, issued a statement saying, I'm not going to publish. Basically, he reneged on his promise from 2012. I'm not going to publish because I've received an opinion from the Office of Legal Counsel at the
William
Department
Barr.
of Justice. No, at the Department of Justice, and they believe that the deadline is valid. Therefore, the ERA is not valid. Now, mind you, neither the Department of Justice nor the Office of Legal Counsel has any power over the archivist. None. Zero. So the archivist was not obligated to listen, or much less obey, what that opinion letter said, but he chose to.
That was based on that memo from the AG William Barr, right?
Yeah, that's the OLC. That was
Yeah.
the Office of Legal Counsel under the Attorney General, then Bill Barr, under Trump.
Under Trump, right?
So I had sued the archivist, and now we were basically asking our federal court judge to order him to publish, because the law says he must. And the law says nothing about not publishing. Even if the ERA were later deemed not valid, he still had to publish.
Right, right.
Publication is untethered to validity. It's a ministerial act.
Yeah, and that's a ministerial office under the executive branch, correct?
It's an independent agency, actually, but it is subject to executive authority. It is subject to executive authority, which is important because the President of the United States could tell the archivist to put the ERA in the Constitution. That's a political decision, and that has yet to happen. But after I filed my lawsuit, another lawsuit was filed weeks later by the last 3 states to ratify. They filed in DC federal court. Mine was in Massachusetts federal court. My judge in the case was a Black liberal female nominated by Obama. The judge in DC was a male liberal nominee from Obama as well. So we both thought we had a good chance, right? My judge could not have been more hostile to women's issues and more hostile to women's equality. She was awful.
She was
And
the African American. The other one was Latino, wasn't he?
I think he was from Puerto Rico. Yep. And he also was brutal and hostile to women's equality. So we were in a bit of a pickle. But mind you, before those 2 judges ruled in our cases, something even more dastardly happened. Ruth Bader Ginsburg, who was very well aware of the 2 lawsuits, went to Georgetown University Law School and answered a planted question from the audience about the status of the ERA. And she said,
The deadline is valid.
the ERA is not valid because the deadline is valid. And that just blew everybody up, because of course that gave political cover to my judge and to the judge in the DC case. They could do what they wanted now, because Ruth Bader Ginsburg, the almighty women's rights person, had said that the ERA was dead. Mind you, if you really know Ruth Bader Ginsburg's work, you would never support her as a women's rights advocate. All of the work she did undermined the ERA and worked against women's equality. And it was really terrible what she did. But I wasn't suspicious of her until she said that at that event. It's so,
Mhm.
it's so,
I know that really, that really struck me when she did
it
that.
struck me in a way that made me
Wow.
think, oh, wow, I need to
Yeah.
go look at her research again and
Mhm.
her work that the cases that she gets celebrated for from the early 70s.
Mhm.
And I was blown away at how much harm she did to women's equality. I read her work more carefully now with a scholar's brain. I was able to really read her work very carefully. And I destroy her in my new piece. I literally take her to the woodshed and point out how she was
Yeah.
single-handedly involved in preventing the ERA from being ratified. And she was
Mhm.
single-handedly involved in undermining women's equality in the courts because remember when we talked about strict scrutiny being way up here and then
Right.
down here is a rational basis where they dumped women in 1971. Although we did get bumped up to that middle piece in 1976, it was still clearly second class equal protection rights. We once had third class. We got bumped up to second class. But it was Ruth Bader Ginsburg and the cases she filed in the early 70s that got us stuck in that second class space.
Intermediate scrutiny.
She never, that's right, it's called intermediate or middle tier scrutiny. She never once asked in any of her briefs, asked the court to give women strict scrutiny and to elevate them up to that top piece of the triangle. She advocated for the middle crappy second class piece while lying to the public and saying she supported women's equality. Even when she got elevated to become a justice of the Supreme Court, she had a chance to write her own opinion in a famous 1996 case. Everybody knows it as the VMI case. It's technically US versus Virginia. She wrote the majority decision. And that was a case where she had the ability to say, I believe women are entitled to full equality with strict scrutiny on par with everybody else. And she didn't. Her own opinion sticks us right there at that second class place where we remain today. And
Yeah.
that was her explicit request. Mind you, then she'd go to a luncheon or something and tell people she supports women's equality and she supports the ERA. She was lying. She was a liar. And
Mhm.
she's exactly the kind of dangerous women's rights types that we need to be careful about, which is whoever gets propped up and celebrated, be very careful. Be very careful because the women who are actually doing women's equality work don't get propped up. People like Ruth Bader Ginsburg get propped up because they're fighting against women's equality, but they're intellectual enough to use the gobbledygook language to create the appearance that they're on our side while they're actually doing destructive anti-equality work behind the scenes. I would say that's true of feminist majority. Remember, I said earlier that when I was at the Belmont Paul House in Washington, D.C., the Women's Party headquarters, Ellie Smeal was on the stage with me. And she said, after I gave my talk and explained what my litigation strategy would be and what my arguments would be about the deadline and being in the preamble and why the Constitution couldn't tolerate leaving the ERA out, et cetera, Smeal got up after me and said, I agree with everything Wendy just said. I almost fell off my chair because I know she's opposed to the ERA. I know she has done horrendous bad stuff behind the scenes to undermine the ERA. And I put a lot of that in my new piece as well. People need to know. But she got up and said, I agree with Wendy Murphy, and we're going to go into court as soon as Virginia ratifies. And this is what she said. I have it on tape. I have teams of constitutional lawyers all over the country ready to go to court the minute Virginia ratifies. And we are going to go into court with all these major law firms, big constitutional law firms, and we're going to get that ERA in the Constitution as soon as Virginia ratifies. Well, guess what happened? Virginia ratified, and she did nothing. Absolutely nothing. She also refused even to sign an amicus brief in my case, as did the ERA Coalition, as did, some more of these fake groups that claim to support women's equality, but actually don't. And in fact, Smeal sent fundraising letters out for the feminist majority every time we won a ratification. It would, like after Illinois and after Virginia ratified, Smeal would send out a fundraising letter, and she did nothing. The feminist majority did nothing to help ratify in any of those states. They did nothing, but they sent out celebratory letters saying, send us more money because now, we're doing all this great work on the ERA. They did nothing, absolutely nothing. And then, by the way,
it was just convenient as a money.
Yes, and Smeal has said as much publicly that the ERA has always been their best fundraising tool.
Wow.
Yeah. So one other quick thing about Ruth Bader Ginsburg, after she gave that talk, she knew that we were suing in Massachusetts federal court. She knew about the DC case. She personally went to the archivist twice and told him not to publish the ERA in the Constitution.
Who did that?
Ruth Bader Ginsburg.
Wow.
And he was so offended that she did that he told people that she did that, which is great in the sense that we now have him on record. But he was very unhappy. And he shared that she went to him, which was extremely inappropriate. But people need to know this about her so they can cut the ties with her, tell the truth, move on. The other thing to know about the National Women's Party and Alice Paul, by the way, in terms of Ruth Bader Ginsburg, was also very hostile to them. And as I said earlier, Alice Paul was marginalized because she was so powerful as a nonpartisan. The National Women's Party, soon after the ERA was sent to the states for ratification, and Alice died a few years after Congress passed it, so that was a problem too. But as soon as Alice died, hostile forces infiltrated the National Women's Party, created two separate entities, and then caused friction, sued each other, and the settlement involved dissolving the National Women's Party completely. Yeah, they dissolved it, and a quid pro quo was that they would be able to keep the party headquarters in perpetuity as a museum. Now think about that. Women's rights don't need a museum. We need current activism. But by creating a museum, the impression was made publicly that we had done all we needed to do.
Right. Yeah. That's why all these PBS specials are always about suffrage and nothing else. It's like, that was the end all be all, and we're done.
Yep, absolutely.
To even, report on.
Yes, absolutely. So women today remain second-class equal protection citizens, which means everything about their lives is subject to unequal treatment under all laws at all times. And I'm talking about the courts, police. It's one of the reasons police disproportionately don't arrest, charge, and prosecute violence against women. It's one of the reasons only about half the states in this country cover women under their hate crime statutes. It's of course the reason women only receive 80 some odd % of pay for equal work compared to men. I keep talking about the triangle, but I like to describe women's place there as numerically representative of the value of intermediate scrutiny, right? Intermediate scrutiny has this wide window of tolerance for discriminatory harm against women, and that includes pay, the amount of pay women get. So, I always say, well, what is it this year? Oh, it's 86%. Women make 86% compared to men. That's roughly the discount from 100%, which is full equality. That number, whatever it is, year after year, that reflects the percentage value of intermediate scrutiny versus strict scrutiny. If we bump ourselves up to strict scrutiny, only a tiny amount of discrimination would be allowed, and it would have to serve a compelling governmental interest. That discrimination, if it were allowed and served a compelling government interest, not just a government interest, but a compelling one, it has to be narrowly tailored to serve that interest, and there can be no other less restrictive means of writing the law so that less discrimination happens. In other words, it has to be as tight as imaginable. And the beauty of that is if I go to court under strict scrutiny and I say this law is discriminatory, if I just say to the court, here's my proof that it's discriminatory, if I rewrite it this way, it serves the government's purpose, but it causes less harm to women. It's tighter, it's less discriminatory. I can't do that now as a lawyer. When I go into court and say my client suffered discrimination, and I say, here's a way what happened to her could have been done differently to not be discriminatory, the court can say back to me, well, you might be right, but you're not entitled to equal treatment. So it doesn't matter. If we, and there's a really stark example of what I just said. Let's say we pass a law that guarantees women equal pay for equal work.
Like the Lilly Ledbetter.
Well, that's not even about equal pay. The Lilly Ledbetter case is so trivial compared to equality, but it just shows you that when some little tiny crumb of a thing improves women's rights, we make a big national parade.
Right. Oh, you remember Obama signed that into law on his first day in office.
And had 800 women there celebrating, and it was the dumbest thing. It's a dumb law. It's not that we didn't need it. It's that it does nothing to cure the underlying problem. Nothing. Absolutely nothing.
What was it?
It had to do with how much time women have to file a discrimination complaint and what gets counted within it. For example, if you suffered discrimination yesterday, but it comes on the heels of 4 or 5 years worth of similar misconduct. Before Lilly Ledbetter, you couldn't consider all of that past conduct unless it was within a certain window.
Yeah.
So the window got broadened, which is fine. But my God, when you're really just trying to stop the behavior, the closing of the window on how much evidence you can include is trivial compared to what you're actually trying to accomplish. So
but even that doesn't really count, does it? Because we don't have.
Well, that's right. Even Lilly Ledbetter can be construed unequally. Exactly. But here's an interesting issue. Let's say tomorrow we passed a law in every state that said women shall be entitled to equal pay for equal work. And let's just say tomorrow it passed in every state. Then the next day, women were paid unequally. And let's say women from every state then went to court and say, hey, that law that says I'm entitled to equal pay, I'm not getting equal pay. In every single state, the court would be free to say, I understand the law says you're entitled to equal pay, and I understand you're not getting equal pay, but the Constitution doesn't require me to interpret the word equal in this equal pay law to mean fully and actually equal. So you lose. That's the problem without the ERA. Even the word equal doesn't have to be construed to mean equal when it's not required to be equally enforced under that strict scrutiny standard. Even state constitutions that have state ERAs do not have to construe, the courts in those states do not have to construe their state constitutional ERAs to require actually equal treatment of women, even though the state constitution says so. Because without the ERA, states have the power in their judicial branches to interpret a state constitutional guarantee of equality for women unequally. I mean, that's how basic this is. Every state can pass a constitutional provision giving women state constitutional equality, and it doesn't give them anything because there's no federal guarantee that state constitutional guarantee of equality will be enforced equally.
So, okay.
So that people need to appreciate that's why we can't fix this at the state constitutional level. It's not a fix.
Right.
Because fixing a state constitution still means that state constitution is subject to unequal treatment under the federal constitution. That
right,
gives
because Yeah, yeah, because it's rooted in that.
It has every law, including state constitutions, has to be rooted in a federal guarantee of equal enforcement and equal treatment.
Mhm.
Otherwise, it doesn't matter what the law says.
And the equal um, treatment, that language is from the 14th Amendment, correct?
Well, it says equal protection,
Equal
but
protection,
but the manifestation of equal protection is in fact
equal
equal treatment
treatment.
and equal enforcement.
Yeah.
That's what protection means.
Mm-hmm.
And there's no other way around it. Like a lot of these silly groups that claim to care about women's equality say, well, let's just get the states to pass laws. No, thank you.
Yes.
It's like saying, let's not abolish slavery. Let's just give the slaves clean socks. You know,
Right.
they
Yeah,
don't need
because
clean socks.
well,
They want freedom.
yeah, because laws can always be, easily overturned by the next Congress or whatever.
Yeah, but you don't even need to. That's the thing. People talk about that all the time. Well, it can be overturned. It's not the issue. The issue is enforcement. So it's not a matter of just overturning. I know everybody's up in arms about what Dobbs did in overturning Roe and so forth. It's not just about the overturning part. It's much more basic than that.
Yeah.
It's about forbidding unequal treatment from the get-go,
Right.
and then it's you don't
Well,
have
I
to
mean, even what I
you
mean
don't have
is,
to over no, but a court, what I'm trying to say is nobody has to overturn anything
right,
when
right.
there's no guarantee of equal treatment to
I
begin,
understand.
right?
Yeah.
You don't have to overturn it. You just have to say it's legal that we do this. And
Yeah.
Dobbs, I have to say talk about abortion for a minute. This is vital, I think, to our understanding of what's really going on with abortion. Abortion got propped up recently, in my view, in part to counteract what's been going on with the ERA, to distract women from the ERA, to get them talking about abortion, even though abortion is not the most important issue for women, not even close. Only about 2% of women need abortions each year. 100% of women need equality 24/7. And if we had equality, that would capture and protect all the abortion issues. So what are we doing? Focusing all our energy on that 2% instead of the ERA, which would fix the 2% and everything else.
Yeah.
So I like to point out the way abortion is being used to distract women, frankly, to force them to vote for Democrats, which is absurd.
Well,
Because
yeah.
let me go back to the
Being
lawsuit.
manipulated.
Let's come back to abortion in a minute. But remember, I said Trump was in office when I first filed my ERA lawsuit in early 2020, but that was also the presidential year. So women voted for Biden Harris in droves because we believed that if they got in, they would make sure the ERA got published. They would rescind the Bill Barr memo from the OLC that blocked
Right,
the ERA
right.
publication. And we believed that Biden's Department of Justice would never keep fighting against us in our two lawsuits. They would
Mhm.
probably remove their opposition and we would win.
Right.
Well, that could not have been more wrong. We voted for Biden Harris because both of them said publicly during the campaign that they supported the ERA. The minute Biden got into office, he did nothing for the ERA. He continued blocking it the same way Trump had. In fact, Trump's letter, I'm sorry, Trump's Department of Justice opinion from the Office of Legal Counsel is still active and in place because Biden refuses to rescind it. He could, but he refuses. So Biden not only did nothing, he kept Trump's OLC letter in
Right.
place.
Right.
He kept fighting us in both lawsuits, and he made exactly the same arguments against women's equality that Trump had made. Because Trump filed briefs in our cases early on, then he lost, then Biden gets in and now he's filing briefs and making the exact same arguments Trump's DOJ had made. There was no change. The other thing is Biden could, as I said, he could have rescinded his opposition in our lawsuits, but instead he announced very quickly after he took office that he was rescinding the Department of Justice's opposition to a trans rights lawsuit in Connecticut, and he made a big to-do about it. He was celebrating it. I'm the best president on earth. I have just stopped fighting against this trans rights lawsuit in Connecticut. Yay me, aren't I terrific? And we were like, why don't you pull out of the 2 ERA lawsuits and celebrate yourself? Nope. He kept fighting, kept fighting, kept fighting in the same hostile way against women's equality that Trump had done. And I was, I was not that surprised by then, because I knew the Democrats weren't helping us at all with anything. And so here it was now, in black and white, Biden being hostile to the ERA, Harris doing absolutely nothing. And we had to keep fighting and fighting and fighting. And eventually Biden won and women lost. And even in the DC case, which went up to the DC Circuit Court of Appeals, and Biden's DOJ was up there arguing, the question was put to their DOJ, well, what do we do with the deadline? Should Congress do something? Is there a role for Congress now? Can Congress remove the deadline?
Right.
And Biden's Department of Justice lawyer said, no, there is no role for Congress on the back end. There's nothing Congress can do. Now, technically, I agree with her. She's right. Congress has no authority to act at this point. They don't have authority to rescind the deadline. They don't have authority to validate the ERA. They don't have authority to direct the archivist to publish. They have, think about this. There's a bill pending right now in Congress being promoted by some, propped up women from Congress saying, aren't we great? Vote for Democrats for Congress because we have a bill proposed that will require the archivist to publish the ERA. Now, mind you, when I say to them, well, what authority do you have to tell a completely independent branch of government official what to do? Like, what makes you think you can pass a law telling some government official not part of Congress how to do their job, or when to do their job, or what to do? Why do you think you have the ability to pass a law telling the archivist to publish?
Right. And how did they respond?
They don't have an answer because they know they don't have authority. But it's the same nonsense as when they say, vote for Democrats for Congress, we will codify Roe. They don't have authority to do that either.
So that would change, though, if we had the ERA in place.
The ERA would actually restore abortion rights. And, not a lot of people understand this, but it's important to understand why. Yeah. Even though the Supreme Court in Dobbs struck down abortion rights, they did so under the 14th Amendment. The 14th Amendment, which speaks to both due process and equal protection rights, the court said that never covered abortion. We never should have said it did. We were wrong. It doesn't. Well, of course, that's absurd, but it doesn't matter, because if we get the ERA into the Constitution, we have no more debates about whether abortion is covered, because the question will come up under the ERA, is abortion and pregnancy and reproductive,
capacity,
reproductive issues, are these things sex-based? Under the Equal Protection Clause, the Supreme Court said, no, pregnancy, reproduction, none of these things are sex-based, including abortion, because men can't get pregnant. That's what the Supreme Court said in Dobbs. Mind you, it's an absurd, really intellectually deranged,
convoluted and ridiculous.
It's intellectually dishonest. It's outrageous. It's false, and they know it. They know it. But the Supreme Court in Dobbs, as a throwaway comment, it wasn't even part of their holding because nobody raised the argument. They said they didn't even make an equal protection argument. The plaintiffs didn't, and the court just, as a throwaway matter, said, we don't have to deal with equal protection because pregnancy and abortion, et cetera, are not sex-based because men can't get pregnant. And in support of that, they cited this ridiculous case from the 70s called Godaldig versus Aiello. Godaldig was something about whether insurance companies can exclude pregnancy as a disability. I think it was in the context of an employment coverage. not insurance, but employment disability. And, basically the court said pregnancy is not a sex-based thing. So we don't have to analyze it as a discrimination question. And that allowed them then to analyze it under these very loosey-goose standards, and they upheld it. Well, the Supreme Court in Dobbs just referenced back to that nutty case from many, many years ago, and without debate or discussion, just threw it out there in dictum, meaning it wasn't part of the court's holding. So one could argue that that part of Dobbs can be ignored and it's worth nothing. But because it's there, it gives us a really strong argument to push for the ERA, because the ERA is different than the 14th Amendment. Remember, the Supreme Court in Dobbs said under the 14th Amendment, Equal Protection Clause, we think pregnancy is not sex-based, pregnancy and abortion. Under the ERA, it is, and here's why. Number one, the language of the 14th Amendment is very different from the ERA. The 14th Amendment equal protection says persons shall have equal protection of the laws. The ERA says, equality of rights shall not be denied based on sex.
Right.
Courts have held that the broad language of the ERA is much wider, much more protective, much stronger than the 14th Amendment. And as a good example, the Pennsylvania Supreme Court in January of this year issued a decision striking down funding restrictions for abortion in that state, striking them down under the state ERA, which reads exactly the same as the federal ERA. And this is important. What the court said was the state ERA is broader than the state guarantee of equal protection. It's broader, it's specific to sex as a category. And we can't imagine anyone concluding that pregnancy and abortion are not sex-based. Indeed, they are quintessentially sex-based in nature. And the fact that men can't get pregnant is irrelevant. They are absolutely sex-based. I mean, the court in the Pennsylvania case all but mocked the Supreme Court for saying pregnancy was not sex-based, but they also just disregarded it and said, it doesn't matter what equal protection laws think about whether pregnancy and abortion are sex-based. Under the ERA, the state ERA, pregnancy and abortion are absolutely sex-based. And it doesn't matter that men can't get pregnant. That's not relevant to our analysis. And because the ERA is much broader than the Equal Protection Clause, we have no trouble both applying it to abortion and using strict scrutiny, that tiny triangle at the top. The strict scrutiny analysis the Pennsylvania court used was as good as it gets. I mean, they said strict scrutiny applies. We would not tolerate this kind of discrimination. It's outrageous and disgusting, et cetera. Therefore, even funding restrictions, which are not as onerous as, say, a 6-week ban on abortion.
Right.
Even funding restrictions didn't make it through. So the Pennsylvania case, it's not the only one of its kind, but it is an important case. It was a couple of 100 pages long. And for people who wonder whether the ERA matters, boy, you care about abortion, you read that case, you get it, because it's a nice, very detailed historical overview of why abortion is sex-based, why we have to have protection against restrictions, because it undermines women's freedom to live in the world. It undermines everything they do if they can't control their bodies. There's nothing more important to the nature of what it means to be a free human being than to have authority over the self, autonomous authority over the body. Nothing is more sacred or profoundly important as a constitutional matter. And boy, does the Pennsylvania Supreme Court get that. So anyone who cares about abortion, who's not supporting the ERA as the solution to this nightmare we're in, is a fool, is an absolute fool. And again, it's,
Okay.
it's a nonpartisan problem. So we have to think in nonpartisan ways about getting this done. And what I've been urging people to do is really very simple. We have to reimagine ourselves as Alice Pauls and be um, there's a big effort underway now to put pressure on Biden to get him to publish the ERA. And he has the power to do that by simply picking up the phone, calling the archivist. It's a woman now. And
Right.
she has indicated that if Biden asked her to publish, she would. So we need to pressure Biden to tell her to
Right.
do her damn job and publish the ERA and
Right.
the Constitution. Because it's an easy thing for him to do. Pick up the phone. We don't, it takes nothing. We don't have to
Right.
pass a law. We don't have to get Congress involved. We don't have to go to court. Pick up the
Right.
phone, tell the archivist to do her job, put the ERA in the Constitution, because that's what federal law mandates. Not chapter, 1 U.S. Code, section 106B is explicit. When the last state ratifies, the archivist must publish the ERA in the Constitution. If there's going to be a debate about its validity, that's for the courts to decide, not the archivist. Now, what's interesting is not just this archivist, but even archivists in the past have said, the president is basically my boss. If he told me to put the ERA in the Constitution, I would.
Yeah.
The president has the power to pick up the phone and tell the archivist to put the ERA in the Constitution, but he refuses to do it. So what I've been urging women to do is to not vote for Biden unless he does this. Now, how are we going to make that happen? Well, we have to make it clear to him. We have to say, you will not get my vote, and you will not get the vote of any of my female friends unless you put the ERA in the Constitution before November. It's between now and November that we have the power to make this happen. It's our only leverage. We will never have the money we need to fight back against the money that's hostile to women's equality. But we do have votes, and we have enormous numbers of them. We're about 168 million strong. There's incredible power in that many votes. But we need to unite and come together and use our voting power in the same way that Alice Paul did, leveraging our one thing we have, which is our enormous voting power, against whoever's in power to make them do the right thing. That has to happen between now and November. We have to make clear to Biden, if you don't do this, we will not vote for you. We will vote for either Jill Stein, Marianne Williamson, or Cornel West, all three of whom have said on day one of their presidencies, they will make the call. They will tell the archivist to put the ERA in the Constitution.
Has Cornel West said that now?
Yes, he has. Yep.
Oh, he has.
Yeah.
Oh, I didn't know that.
All three have come out. And
when did he say that?
Last week.
Last week.
Yep.
Do you have any kind of a link or anything on that?
Yes, I do. Remind me. I'll send it. So now,
okay, or you could put it in the chat. Yeah, later.
I don't know how to do that. Yeah, I can send it to you. So, people will say back to us, well, if you don't vote for Biden, you're voting for Trump. And my answer back is, that's absolutely false. Biden doesn't deserve my vote if he's participating in women's subjugation by refusing to pick up the damn phone and call the archivist.
Right.
And if he loses, if Biden loses because he refuses to elevate women out of their chronic, pervasive subjugation as second-class citizens in this country, then that's on him. That is on him. And we will not be used as ping pongs, batted back and forth from one party to the other, because neither party actually supports women's equality. We're not going to be partisan. That gets us nowhere. We're going to be nonpartisan. We're going to hold both sides accountable. It so happens Biden is in power right now. If Trump were in power, we'd be saying the same thing to Trump.
Okay, now here's what I need to ask you. Okay, so the first person who said they would instruct the archivist to publish the ERA on her first day in office was Marianne Williamson, and then Jill Stein did more recently, and then now you're telling me Cornel West has.
Yeah.
The problem with all three of them is they also are totally
not going to win. Yeah, but here's the thing. Let's talk about
no, that's not where I was going with this.
Oh,
This is specifically for the FIST group. I want to
oh,
address
go ahead.
this issue.
Go ahead.
They all three, the problem with all three of them is they also totally support these trans rights demands for, you know, that the Equality Act, which would basically enshrine gender identity as a protected class, just like, you know, like sex, that like they include.
Oh, here's the thing. Here's the thing. I'm trying to hurry because I got another meeting. You know, the funny thing is, if you support the ERA and if it gets into the Constitution, it is going to establish equality across the board for everybody, and no one's going to be left out, which is important. Whether you support the language of gender identity or not, the bottom line is the bottom line is it's the hierarchy and the pitting of groups against each other that's the primary problem. If the ERA gets in the Constitution, it only uses the word sex, but the Supreme Court has already said sex is the catch-all that includes other categories like gay and lesbian.
Right.
And
Well, they're
yes, it's
conflating.
also and trans. The Supreme Court
Right,
has
right,
already said
right. But
sex covers trans. So there's no need for us to worry about whether some statute somewhere collapses gender identity and sex. I mean, I do worry about it now, but with the ERA in place, I don't worry about it. The ERA will override any of that by protecting sex as a category explicitly, and that means it cannot be subsumed within gender identity, no matter what the Equality Act says. That's important because the Constitution as a law is a heavier hammer than a mere statute, and we all understand that. The other thing to keep in mind is, since we already know sex is the umbrella category that captures all ways of being when it comes to sexuality and things of that nature, we don't have to concern ourselves that somebody feels like their category ought to be more important or better or different. The reality is the law is already there that says sex is the category, the leading category. And if you are gay and the word sex covers you because you're gay, and then you suffer discrimination because you're gay, but you also happen to be female, the important point is that the law says if you suffer discrimination because you're gay, you're entitled to that categorical level of protection the same way you would if you suffered the exact same discrimination because you're female. That's
okay,
what
but
we want the law
what I
to
want to
say.
get to. Here's what I want to get to. What's really concerning though for us is, you know, what's going to happen to women's safe spaces,
Yeah.
and please don't minimize that, because, you know, women have a right to privacy, safety, and dignity. And, you know, what's going to happen to women's safe spaces and sports and everything else if gender identity, like, you know, the thing that's being pushed by Wolf, the whole Women's Bill of Rights thing, which is pushing for intermediate scrutiny, you know, but, you know, their biggest concern is
Yeah.
because of, you know, the invasion of women's
Right. So let me cover it. Let me cover that. Okay. You know, there are some people out there who are trying to divide women by pitting us against each other on the theory that intermediate scrutiny is somehow better for women. Let me be clear. That is the most absurd, inane, deranged thing anybody could say. You should support yourself as a second-class citizen under all laws, because that's the only way you're ever going to be able to have a safe space in a bathroom.
Yeah, so explain how we can have safe space.
What the hell? First of all, who would be so dumb as to think second-class protections under laws like slavery, laws against slavery, laws against freedom of speech?
But tell us how it's going to.
No, I want to be clear. Why would anybody say it's better to be a slave so long as you can have your own bathroom? That's dumb. Dumb. Women are dying at very high rates because they're not entitled to equal protection against homicide. And that's not more important than a separate bathroom.
Okay, yeah, but
that's the one. I know, but that's important. That's important. The second point is there is zero reason to believe that under strict scrutiny, you can't have separate spaces as a woman. And here's why. And I address this in my new piece. Strict scrutiny doesn't say zero discrimination. It says there has to be a compelling need for the discrimination. So what kind of discrimination would there be a compelling need for? Virtually everything where privacy and safety and I might say equal competition in sports are at stake. All three of those things are compelling state interests. And why do I know this? Because there are times under compelling state interest when even racism is allowed under strict scrutiny. Example, if you want to hire a Black person for the role of Thurgood Marshall, you can't be told by the law that that's discriminatory because you're favoring a Black person for a role to depict a Black person. Why is that important? Because so long as strict scrutiny allows any discrimination, and it does, it will always allow discrimination where there is something other than discrimination going on. What are those other things? Safety, privacy, when you're nude especially, and equal competition in sports. Why do I know these three things merit ongoing respect under strict scrutiny? Because they've always been respected in the law in very strong ways. Equal competition in sports, even without male versus female sports, we have an obsession with making sure the competition is fair. That's not going anywhere. It might be in flux right now because there's a lot of crazy stuff going on. That is going to be resolved in favor of no biological men at a serious level of sports. I don't think anybody cares that boys and girls play each other in first grade or second grade.
Right.
The second point, safety. There is never a place in the law where you cannot argue that safety and well-being is a valuable, not just valuable, compelling state interest.
Right.
Worthy of respect under the law. Even in the most recent case where the Supreme Court struck down racial preferences in college admissions, they still said schools can take into account a person's experience with racism in their life. If schools can take into account a person's experience with racism in their life, then anybody, any court can take into account women's experiences with sexual assault, sexual harassment, sexual abuse, any kind of harm they endure because they are female when deciding whether separate spaces are necessary. So let's be clear about that. And the third category, privacy. The law always protects and respects privacy because nudity and the privacy rights we recognize around nudity have always been in place in the law as a compelling state interest, compelling enough that you can go to prison if you pull your pants down in public. So we have protections in the law that see this privacy arena, if you will, as worthy of very serious consideration. And if a woman or a man can show that there's a need for privacy, and there always will be when nudity is involved. You might not need privacy when you're not nude, but when there are body parts showing, the courts will uphold the need for privacy, not because you're female, because you're nude. So when you have what I call discrimination plus situations, and that plus is a legitimate government interest, and I just named the three major categories, there's no doubt in my mind the courts will still respect the need to honor those categories and allow quote unquote discriminatory separate treatment, just like we allow, as I mentioned before, you can hire a person who's Black because they're Black, which is a favorable preference, if you need them to play the role of a Black person. I mean, I could go on. There's so many
Yeah.
examples of situations
So are
where
you, yeah, are you saying that the ERA then would fix the current problem that we have with these trans-identified males invading
that
bathrooms?
the ERA not only wouldn't hurt, I want to be clear. Some groups say the ERA would hurt because it would require strict scrutiny, and intermediate scrutiny is where we let women get special consideration. Not only is that a lie, and not only would it not hurt, the ERA would dramatically improve women's arguments in favor of separate spaces, separate sports, and so forth, because it recognizes women as worthy of equal consideration as a class of people. I mean, this is how simple it is. We are currently being disrespected in the trans versus sex debate, in the gender versus sex debate. Women are being disrespected because we're in this crappy second class place in the law. We don't sit very high up. And when you're a second class person, your voice, your interests, your well-being are always of second class concern. We need to get bumped up to first class. And it is from that first class position that we have stronger voices. And when we say the things we need to say about why we need separate spaces, about why sports should be fair, and so forth, our voices will matter more in the scales that we're balancing against other people's concerns and interests. This is really not complicated. What we need to do is just use some common sense and appreciate the fact that a lot of people who say that second-class treatment under intermediate scrutiny is better for women are actually being funded by anti-ERA forces, by anti-women's equality forces. They're masquerading their argument in favor of enslavement of women and second-class citizenship by packaging it as some form of benevolent protection that we can't otherwise have. That's the same crap we heard from Phyllis Schlafly back in the day. Oh, you need protection. You need protection, or else, you're never going to be able to survive on your own, and blah, 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 blah. Schlafly was a male supremacist.
Right.
And she was
absolutely.
She was sounding protectionist in all the ways that appeal to women who worry and don't have the ability to think deeper thoughts.
Women who don't have the information that they need to make a.
That's right. So they either aren't thinking or they don't have the information. But I'm saying either way, she was pandering to the lowest common denominator and making it harder for women to see the truth. And that's exactly what's going on with these arguments about intermediate scrutiny today. I would debate anybody on this issue, and I would never support anyone who says second-class citizenship is better because at least it allows the government to protect you from, bathroom spaces or whatever. I don't know what comes over people that they would open their mouth and those words would come out. It's like it's like Black people in the South prior to the 13th Amendment saying, "No, please leave us here on the plantations." And by the way, there's some merit to this, right? In terms of what they were thinking. There were Black slaves in the South prior to the 13th Amendment that said, please don't rescue us from our enslavement. We're afraid of what will happen if you free us. We're going to get killed. We're going to get lynched. And it happened. They were right to be afraid. But you don't say to those people, you're right. In order to keep you safe, we're going to keep you on the plantation. We're going to just leave you right there in your shitty slavery. And you'll love it because at least you're safe. Who would say that? Who the hell would say that? What we would say is, we're going to liberate you from slavery, and then we're going to do unbelievable things with your newfound political power to make sure you're safe. That's what women need to be thinking. Right.
I think so many women are just so afraid because they've had so many terrible experiences.
Yep. The thing to fear is the amount of money being made today on the backs of women's inequality, and literally in many cases on the backs of women because
Yeah.
they're being enslaved by sex trafficking, pornography,
Right.
the amount of money being made from women's violent subjugation, especially in porn and sex trafficking, is so huge globally, so huge today that I think even with equality, we're going to struggle for many, 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 many years to make it work. But without it, we're doomed.
Yeah. Yeah, there's so many forces, and money is king.
Yep.
Since we have those two crazy legal doctrines of corporate personhood and money is speech,
Yep.
that has really enabled money to completely subvert our democracy.
Yep. And I should emphasize one more thing, because I say this in my TED Talk, and I hope people will watch my TED Talk, but I'm going to say it just in case they don't. The way to think about how meaningless it is for us to waste any more time as women passing laws or fighting for, new federal statutes, even new state laws, even new state constitutions. This is the reason this is a profound waste of our time, is because knowing what we know about what unequal enforcement means, it's really, you're just pushing crumbs around on a cracked plate. They just fall through the cracks, fall through the cracks. Every time you pass a law, it falls through the cracks. What we need to do is fix the plate first. That's the ERA. The ERA fixes the plate. And then when you pass laws, they don't fall through the cracks. It's really that simple.
Yeah, yeah. The laws actually stick.
They stick. They at least don't fall through the cracks. We might, as I said, it'll take a long time to get them where they need to be, but at least we'll have a tool to make the argument. At least when I go to court on behalf of my clients and say she's not getting equal pay and she's entitled to it, the judge can't say back to me, well, she's not actually entitled to it, because
Right,
that law is not rooted in a guarantee of equal
right.
enforcement.
They
I
can't say that like Scalia did.
That's right. But what Scalia said in
Was-
2011 was actually correct. And
I
I
know.
thank him every day for saying it out loud, because it's an important thing for us to remember.
Right.
He said, it's not that the Constitution requires discrimination against women. The only question is whether it forbids it.
Prohibits it.
Doesn't. And
Yeah.
he's absolutely right. Now, he did lie in that same interview when he said, no one ever thought that's what the 14th Amendment meant. He's wrong. Women did think they were persons in 1868. We did think we were covered by that language. And it was
Of
only,
course. I mean, it would be
yeah,
nothing but logical to think that we were.
yes, yes. But so he was wrong when he said nobody ever thought that's what it
Yeah,
meant.
and nobody like him.
Everybody thought it covered women, and it was,
Right.
and everybody knew, because it was a bit of a conspiracy among government officials. Everybody knew that using the word persons would keep women quiet, and that they would then lose in the courts, and it would be kind of a more quiet destruction. If they had just said men in the first section of the 14th
Right.
Amendment instead of just the second one where they spoke about voting rights, women would have lost their minds.
Yeah. Yeah, but once again, we're rendered into invisibility.
Yep.
Well,
Invisibility is a problem, and we have emerged from invisibility, but barely. We're barely visible. And, I think people, when we talk about the long picture of women's history, there was a time when laws wouldn't even have included the word male for the purpose of excluding females. So I guess we bumped up a step when
right,
in
right.
68 they bothered to put the word male in there because they knew we were angry. Well, we've only just begun to fight, is all I can say.
Yeah.
There's so much time between 1868 and 2024, but when you really think about it, that's nothing. And we have so much further to go in a way that isn't being addressed because our leadership is corrupt. And I do think we have to say that out loud as well.
Yeah.
All major women's groups are useless and corrupt. They are either proxies for the Democratic Party or funded by the Democratic Party. In a smaller sense, there are proxy groups for the Republican Party, and their entire purpose in life is to keep women fighting against each other in this seeming left-right battle so that
Right.
we don't ever come together
Right.
across all those lines and rise up.
That's always a tactic, divide and conquer.